And this is how it would look like before RA 9552. So you see that great rectangular box and different demarcations as that define the Calayan Island Group USUK Treaty. Then the PD 1599. What's so important about the international treaty limits? And I'm going to discuss the interplay between international and constitutional law. How do we use international to our own advantage? Is it the case that we don't stand a chance if we assert the international treaty limits in the international realm? Because that is really the contention of most advocates of the UNCLOS, that we have been overtaken by history, and we have made our own decision that we should join the that legal regime, and we cannot do much about it if we don't want to be left out. We had better agree to the full extent of the meaning of acceding to that treaty or agreeing to it. But how do we stand before international? Our claim is really unique. It's the only one in the whole world that has such a configuration. Next. We have to understand also that as a state, we should make claims about territory. People who say that the state is dead in the 21st century must be dreaming. The fact that people are still killing up until the 1990s in continental Europe, killing each other in the name of the state, in the name of that dream. Just recently, I think 3 months ago, the ICJ came out with a decision on the Kosovo case, although even if it was actually a disappointing decision. But that case actually tells us how important it is for a state to have a well-defined territory, or for a state to have its self-determination. Now, when we define territory in the language of international law, it's a part of the planet Earth subject to the exclusive sovereignty and jurisdiction of the state. In the case that also spelled doom for us in some sense, the Las Palmas arbitration, because it gave to Indonesia the Las Palmas Islands, and the Indonesians are using much of it to define the baselines. They're eating up, I think, 15,000 square kilometers of what used to be fishing grounds for the Philippines, because that they use the Las Palmas Island as a reference point for drafting their new baselines law. But territory is one of the elements of statehood. And no self-respecting state can say that I am a state without territory. And territory is very much important in delimiting who we are, expressing as well our nation as people. Now, as I said, the Philippine archipelago is the only mid-ocean archipelago whose territorial domain has been specifically defined and delimited by latitudes and longitudes that have been embodied in international treaties and drawn in international maps of charge. You can't find any other such claim anywhere else. It's only in the Philippines. Only the Philippines has such a claim that has been embodied in treaties and charts and maps and defined according to longitudes and latitudes. That is why it's a unique claim. And that is why we say that, in fact, this legal regime that we find containing international treaty limits precedes the UNCLOS. So on the basis of historic title, the Philippines claims a rectangular territorial sea fully enclosing the entirety of the archipelago, which at some points exceeds 12 nautical miles in breadth. So as a successor state, because we succeeded the US after 1946 under the Titans of the Act. So we are a successor state to the territorial area whose needs and bounds are likewise specified in its international treaty limits, claims that it has exercised uninterrupted possession and occupation over this territory for a period of almost 400 years. Next. It's claimed to a territorial sea limit exceeding 12 nautical miles in some areas but less than 3 nautical miles in others, finds support in various legal documents recognizable under international law as well as by continuous exercise of sovereignty and jurisdiction. And this is something that we should really carefully look at. You know, how do we fare if shall we fare if in case we bring this up to an international tribunal? From the point of view of international law, what is the status of these international treaty limits? Of course, most lawyers are familiar with estoppel and acquiescence. This estoppel is as a domestic principle. When these treaty limits were established by Spain and the US, there was absolute silence. Nobody protested. For almost half a century, from the time of the ratification of the Treaty of Paris, against the exercise of the sovereignty by the US over the land and sea territory of the Philippines, embracing the said treaty. The international community cannot now say that, you know, that's illegal, what they're doing is illegal. Because, well, it says there, for almost half a century, long silence, longer than the 2 years that it took the government to protest against the Spanish submissions, rather the Chinese submissions, under the UNCLOS. Oh, in 1946, when the U.S. granted independence to the Philippines, which duly exercised sovereignty and jurisdiction over the same territory, never was there any protest. There was no protest at all. And that long silence speaks a lot. It speaks to us now where we stand as a silence of acquiescence and estoppel. You know, your behavior before binds you. You cannot now make a protest if before you do not say anything to the idea. It's like that. You know, you cannot just not contest something, say that, well, I have some rights to it, when we did not do so when it mattered most. The very first instance you should have raised a protest as to the effect of those claims over against your own interests. So what we first announced to the world in diplomatic codes our official position with respect to the territorial water claim in 1855. There was no protest from the US or any third states for that matter. And even Spain has been consistent in accepting the limits of the territory of the Philippines as embodied in the international treaty limits. The US only started protesting in 1986. They saw the cable through the US Embassy in Manila. Nearly 30 years after the fact. We also have maps, as we said. All these maps invoking the treaty limits. It's interesting that right now Cambodia has filed a case before the ICJ, asking the ICJ to interpret each judgment in 1962, a judgment that they won by maps. And in that case, you know, well, depending on whether you're Cambodian or you're Thai, Praya Bihir or Praya Bihar. But Cambodia's won in 1962. Now they're asking the ICJ to interpret what exactly that meant, because until now Thailand is still contesting the grant of sovereignty over the temple. They're saying, well, the temple belongs to Cambodia, but the land belongs to us. But that case illustrates how important maps are. And we're not just talking here of any maps. These are maps officially drafted by the US government, by their geological survey. So you have the US Coast Guard Coast and Geologic Survey publishing charts that also embody these international treaty limits. Next. There was also disagreement, as we said, between the US and Great Britain, signing the convention delimiting the boundary between the Philippine archipelago and the state of North Borneo. Take note, the language there is very specific. It could not be more specific. It said there, the boundary delimiting, the convention delimiting the boundary between the Philippine archipelago and the state of North Borneo. marked portions of these charts indicating the Treaty of Paris lines were attached to the same treaty and made part thereof. These are submissions of the US itself. You also have these colonial legislation. Of course, the earliest would be the Philippine Autonomy Act, known as Jones Law, which everybody was asked to memorize in grade school. It also defines their international treaty limits. And the 1934 McDuffie Act, officially known as the Philippine Independence Act, approved self-government and independence for the Philippines after the 10 years over all the territories ceded to the US by Spain. That clearly indicates the international treaty limits. So this is what Batongbacal said. You know, the Philippines, the US, in denying that the Treaty of Paris defines the political boundaries of the Philippines, the US called it its own major legislative enactments of colonial policy governing the Philippines. These enactments stand as interpretations of the Treaty of Paris on the part of the US government and be held binding on itself. Some Filipino scholars like Florentino Feliciano surprisingly say, well, these documents do not really talk about boundaries. He has a different interpretation. Over and against the clear language of these treaties themselves. Expresses saying that these are boundary lines. These are exactly our territorial limits. So if you look at now as up until before RA 952, we have this the international treaty limits as established by the Treaty of Paris and other treaties, and then the subsequent enactments, baselines law. The baselines law RA 3046 was passed by the Philippines after its declaration that it was adopting an entirely different archipelagic theory. A theory that the archipelago of the Philippines is integrated and cannot separate the waters from the land they're in. So you cannot subject it to this three-level legal regime of maritime boundaries, because the Philippines, according to the Philippine position at that time, first declared, is an integrated land and water territory. You cannot separate water from land, and in fact, it has international law behind it. It has all these enactments by the colonizing power that expressly stated the status of what the status is of these international treaty limits. Now, we have this principle in international law, although it was first applied by the ICJ, by international tribunals, to land demarcations. You know, the idea, the doctrine, which was developed under the international decolonization. As I said, in the 60s, there was a different twist in the meaning of self-determination. Before, self-determination meant that no foreign power can meddle with their own affairs. Beginning in the 1960s, you have all these decolonizing states, emerging states, that started to assert themselves in the international arena. And one of the principles that came out of this is the principle of international law of uci possidetis juris. What exactly does that mean? Next. In the case of Burkina Faso, Republic of Mali, the ICJ said there is no doubt that the obligation to respect pre-existing international frontiers in the event of state succession derives from a general rule of international law expressed in the formula of uci possidetis. In this case, the uci possidetis juris served to freeze the title over territory at the time of independence, in effect producing a photograph of the territory. So this is an analogy when you take a picture, it freezes. So applying that to colonial boundaries, the ICJ in several cases, Libya versus Chad, Burkina Faso versus Mali, the ICJ said, well, the effect is like when you're taking a photograph, it freezes the boundaries. It stays there long after the colonizing powers left. And the reason for that is, according to the ICJ in several decisions, it is the need for boundaries. Now, and in fact, it was observed that in Africa continent, where this